Let's take a quick look at the legal reasoning used in Roe versus Wade. Now, it's going to be a quick look because it's not really what we're going to be interested in this class, the legal reasoning. It's important to understand the legal reasoning to understand the decision and how it works, but it's not really what ethicists or moral philosophers, people in an ethics class, are interested in. And so before we get into the legal reasoning, I want to just explain that a little bit, this difference between ethics or moral philosophy and law. And I want to address this very quickly because there's a temptation, I think a lot of students have it, a lot of people have it, students or people, to conflate law and ethics, to think that, for example, if something is, what is it for something to be morally right? It's for it to be legal. What is it for something to be morally wrong? To be illegal, right? And so if you follow the law, you're doing all the morally right things. If you, and you're not doing any of the morally wrong things. And so morality and the law, I don't know, they kind of go together like this. That's not correct. That is incorrect. That's not how things work. It's much more complicated than that. The relationship between the law and ethics is much more complicated than that. And I think one way that we can get at this is by considering the nature of ethics or moral philosophy and the kinds of things that ethicists and moral philosophers are interested in. They are interested in more fundamental issues. A judge or a lawyer is going to be interested in whether or not something is legal or illegal, constitutional or unconstitutional. The moral philosopher or the ethicist, when we're doing ethics, we're interested in more fundamental issues. We're interested in whether or not something is actually right and good or bad and wrong. And one way to really see the difference here is to recognize that what's legal or constitutional can be different from what's morally right or wrong, that morality and the law can come apart. And so certain immoral behaviors, immoral actions, maybe seriously immoral actions, might be legal. And the mere fact that they're legal doesn't mean that they're right. So, for example, prior to the passage of the 13th Amendment, which was one of the amendments passed in the aftermath of the Civil War, prior to the passage of the 13th Amendment, it was legal and constitutional to own slaves in the United States. Clearly, slavery is morally abhorrent. It's morally evil, wrong. Nonetheless, it was constitutional. And so a judge or a lawyer who was looking at, who's considering slavery prior to the passage of the 13th Amendment, their question would have been, is slavery constitutional? And the answer would have been yes. A moral philosopher, at least moral philosophers who know what we know today, right, were they to consider slavery, their question would be, is slavery morally wrong or is it morally permissible? And of course, they would, knowing what we know today, it's morally wrong. It's morally reprehensible. And any constitution that allows for it is a defective constitution. Yeah. What that points out is that the law itself, the things that we have on the books as laws, might be wrong. They might be unjust. And ethics, and so this is the sense in which ethics or moral philosophy is concerned with more basic questions. We're concerned when we're doing ethics with what's actually right and good, what's actually bad and wrong, what in truth is right and good. We are not really concerned with what the American legal system holds to be permissible or impermissible, what's legal or illegal, because the American legal system might be wrong about certain things, or might be silent about other things, or whatever, right? The law and ethics are two different issues, are two different topics, two different subjects. There's interrelations there, sure, but and moreover, the law might be wrong, and the standard for the law, you might argue, is going to be something like ethics. Ethics judges whether or not these laws are right or wrong, or it's by doing ethics that we figure those kinds of things out. It's by asking questions about ethics, asking ethical questions as opposed to merely legal questions. If you're just asking the legal questions, you're never going to raise that further issue. Yeah, fine, this is constitutional or this is legal, but is that proper? Is that morally acceptable, right? Maybe the Constitution needs adjusting. Well, that's going to be more of a moral or ethical question, less of a legal question. Okay, and what we're really interested in this class is not merely whether or not, or in particular in this unit, not merely whether or not abortion is legal or illegal, constitutional or unconstitutional, or whatever it might be, right? We're not interested in those questions primarily, although we're going to look at that, obviously, because we're looking at Roe versus Wade. What we're really interested in is the reasons people have given for thinking abortion morally permissible or morally impermissible. And that question is it kind of precedes the law, or it's above the law. It's more fundamental than the law, because presumably whatever the answer to the moral question is, the moral question about abortion, there's room for debate here, but you might think that whatever the answer to the moral question is should perhaps determine what the law is, or at least should be taken into consideration when we're determining what the laws are going to be. All right. So in this unit, in this class, we're more interested in the moral question, less interested in the legal question. But since we're looking at Roe versus Wade, we're going to consider very quickly this legal question. And we're going to look very quickly at the legal reasoning. So Roe versus Wade was penned by one of the justices on the Supreme Court at the time, Justice Blackmun. And so in going forward, when we're talking about Roe versus Wade and the reasoning and the decision, I might occasionally just refer to Justice Blackmun. That's because he's the justice who wrote the decision. All right. So what is Blackmun's legal reasoning here? He rests the reasoning. And so when I talk about the legal reasoning behind Roe versus Wade, I'm talking about the kind of very general orientation for the decision. We'll get into the specifics later. The very general reasoning behind the decision, right? The most kind of general reasoning. What is that? He rests it on the 14th Amendment. And in particular, Section 1 of the 14th Amendment. That's the part of the Constitution that is most relevant for Justice Blackmun and for the decision in Roe versus Wade. And so there you see the 14th Amendment right there. I'm not going to read the whole thing because he doesn't use the whole thing, and the whole thing is not relevant. And typically, right, the 14th Amendment is, I don't know, it's not a popularity contest, I guess, but it might be one of the most popular, most famous amendments. It's trotted out quite a bit. And usually when people are talking about the 14th Amendment, there are, I think, 4 sections to the 14th Amendment, but usually when people are talking about it, they're talking about this first section. It's this first section that set many precedents, and many Supreme Court cases are based upon, Roe versus Wade being one of them. Not even the whole thing, though. What Roe versus Wade is really concerned with is what's called the Due Process Clause of the 14th Amendment. And that is the bit that is in bold there. And what it says is that no state shall deprive any person of life, liberty, or property without due process of law. Now, you might think, well, I don't know, that seems fine. That's no, how are you going to wring anything out of that? Well, let's see how Blackmun does, right? It might seem a rather kind of anodyne statement, but there's actually the ramifications of this due process clause have been immense This is, like I was saying, one of the most famous bits of law in the Constitution. Okay, so a state cannot deprive any person of life, liberty, or property without due process of law. First thing to look at here is that word liberty. That contains or implies quite a bit for Justice Blackmun in particular, but the Supreme Court more generally. The idea that has been developed in the Supreme Court since the passage of the 14th Amendment is that there are certain unenumerated rights or liberties that this clause of the 14th Amendment protects. Unenumerated. They're not mentioned, not by name. You don't actually find these liberties written down, or these rights written down in the Constitution anywhere. Rather, the idea is they're kind of contained within that word liberty right there in the 14th Amendment. And so what Blackmun claims is that that word liberty there in the 14th Amendment includes what he calls the right of privacy. There is a right of privacy guaranteed by the Constitution of the United States. Well, what? That's not anywhere in the Bill of Rights or anything like that. It's right there in that word liberty in the 14th Amendment. That includes a right of privacy, according to Justice Blackmun. And not just him, many other justices have thought something like this. Many legal scholars think something like this. Liberty there includes the right of privacy, which in turn includes the right to procure an abortion. This is Blackmun's argument in Section 8 of Roe versus Wade. I have the text there. I'm not going to read it, in which he lays this out. But that's the idea. Liberty there in the 14th Amendment includes the right of privacy. The right of privacy includes the decision to procure an abortion. And so there is a fundamental right or liberty to privacy, a fundamental right or liberty to procure an abortion, according to the Constitution, according to Justice Blackmun, according to Roe versus Wade. Now, one thing you might notice from before I get to that, one thing I should say, other legal scholars and other Supreme Court justices have been trenchantly critical of this view of the 14th Amendment. And so perhaps most notable today, Justice Clarence Thomas thinks this is ridiculous. And he's very forceful in the way that he argues against this interpretation of the 14th Amendment. According to someone like Justice Thomas, there is no right of privacy in the Constitution. Why? Because it's not there. It's never mentioned, right? The 14th Amendment saying that no state shall deprive any person of life, liberty, or property, that doesn't imply that there's a right of privacy, which includes a right of abortion. This is all just kind of, according to Justice Thomas, this is all just kind of made up by the court, by Justice Blackmun. And so Roe versus Wade should be overruled, and so blah, 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 whatever. So that's kind of the Justice Thomas's position. The two dissenting justices to Roe versus Wade, so Roe versus Wade was decided 7-2. The two dissenting justices, Justice White and Justice Rehnquist, they both thought something similar. They thought this interpretation of the Due Process Clause of the 14th Amendment was incorrect. That's not what the 14th Amendment is getting at. Okay, so this is controversial, right? Somewhat controversial. Now, okay, so going along with Blackmun, no state shall deprive any person of liberty, which includes the right of privacy. No state shall deprive any person of their right of privacy. Shall infringe, you might think of it this way, shall infringe on their right of privacy, which he also thinks includes the right of to procure an abortion. No state shall infringe upon a person's right to procure an abortion. But that's not all that this clause states. It keeps going. Without due process of law. And so what that implies is that the state can, in fact, infringe upon your liberty, infringe upon your right of privacy, your right to procure an abortion. But when it does so, it has to do so with due process of law, right? What the 14th Amendment lays out is something like a framework for how the state might legitimately infringe or constitutionally infringe upon the fundamental rights or liberties of the people. That's what this without due process of law is picking up on. That's the other really important part of this passage. And the basic idea here is that the fundamental rights or liberties of the people may be infringed upon if there is a, quote, compelling state interest. That's the key phrase. That is a bit of legal jargon. If this were a law school and we were taking a law school class, what we've just seen, this stuff about these unenumerated rights within that word liberty, this stuff about due process of law and compelling state interest, so on, that would be what you would look at. That you would spend multiple classes on that. This is very, very important for constitutional law. Compelling state interest. Like I was saying, that's a bit of legal jargon and it can be hard to suss out what exactly that means, a bit of legal jargon. Think of it like this. Here's an example. So let's not worry about abortion right now or this right of privacy or something like that. Let's choose a different fundamental liberty, fundamental right. One that is easier to understand and that's clearly there in the Constitution. No one could disagree with it, not even, someone like Justice Thomas or whatever. The right to free speech. Yeah, that's a fundamental liberty guaranteed to us by the United States Constitution, right? That's a liberty we have, a right that we have. Does that mean that the U.S. government or the state governments can never infringe upon our speech? No, it doesn't. They can infringe upon our speech if there is a compelling state interest in doing so. So, what the Supreme Court has ruled is something like the following. The state has a compelling interest in making sure that lawless action doesn't occur. Make it even more specific. And making sure that the citizens aren't assaulted, say, physically assaulted. Okay, so they have a compelling interest in that. Now, let's say after the pandemic and coronavirus stuff is over and things kind of go back to normal, all of the philosophy professors are gathered at the Crown Center. Yeah, we're all there sitting around doing whatever we do. Who knows what that is? And you decide to get a bunch of your buddies together who hate philosophy and philosophy professors. I don't know who those people are, and you're kind of gathered around the Crown Center and, you start kind of, I don't know, you're having a rally. I don't know what you're doing. But you kind of start riling people up. Yeah, these philosophy professors, they're making us, write all these papers and man, this is the worst. And these guys, and yeah, I don't like these people. And so you start riling them up. And you then say something like, let's go physically assault these philosophy professors. Yeah. The Supreme Court has ruled that the state of Illinois or the federal government, if it so chose, could outlaw speech like that. And if you complained, let's say Illinois had a law against speech like that, speech which incited an imminent lawless threat, right? It's speech that's inciting people to commit a crime, assault. The state of Illinois or the federal government could outlaw that. And if you, and so you say something like that, let's go, show these philosophy professors what we really think about their classes or whatever, right? I got my club and you got your pitchfork and okay, let's go. the police could arrest you and take you to jail and charge you with the crime. And if you were to try to defend yourself saying, look, I have a First Amendment right, I have the freedom of speech. You can't arrest me for this. I didn't do anything illegal. My right to speak was violated by the police. What the courts would undoubtedly say is no, that's not true. The First Amendment doesn't protect that kind of speech. Speech that will lead to imminent lawless action, not protected by the First Amendment. You are not free to engage in that kind of speech. And you might think, well, yeah, I don't know what you think about that exactly, but maybe your hatred for philosophy professors runs so deep that you think this is ridiculous. But most people, I think, would want to say something like that is, that's plausible, that's reasonable. Yeah, you have fairly extensive liberty in what you say, but yeah, you can't rile people up to go commit a felony, to break the law like that. So it's not constitutionally protected speech. That's the Supreme Court has been fairly clear about this. And so what we have there, what that's an example of, is some basic fundamental liberty we have, namely the right to free speech, to speak as we wish, that the government can deprive us of or limit or infringe upon. But they have to do so with due process of law, and that means there has to be a compelling state interest. There is, in the case about speech, the example I was giving, the compelling state interest would be the health of the citizens. So in particular, the philosophy professors who happen to also be the citizens of the United States. The state has an interest in their health and well-being. The state has an interest in maintaining law and order. And so far as there is this compelling state interest at issue, they can curb that kind of speech. That's the idea, right? So just because there's this fundamental liberty doesn't mean it's absolute. That's the way Justice Blackmun talks. And he applies that to this right of privacy, the right to procure an abortion. So we have a fundamental liberty, fundamental right to procure an abortion, according to Justice Blackmun. But just because we have a fundamental right to procure an abortion doesn't mean that the state can't infringe upon that right in certain specific ways. Doesn't mean that the state can't regulate that right. According to Blackmun, the state can regulate abortion in certain highly specific ways. We're going to talk about those ways in a subsequent video. But that's the legal reasoning behind Roe versus Wade. It rests upon the 14th Amendment, this idea that there is a right to privacy, which includes the right to abortion, and that right can only be limited or infringed upon for compelling state interests.